Present disability for us. Here you go, Joann. It's all yours.
Thank you. Okay, good afternoon, everyone. Thank you for joining us this afternoon. Insurance was a bit quicker than I expected, so sorry for the bit of a holdup. So today we are going to talk about disability retirements. So let's get to it. Again, I always note the resources that I always go to when we're talking disabilities, because I think it's important to know where those resources are. And more than often than not, I am going to statute to look at words in the language and to ensure that I am able to provide the correct information when I do get questions. So definitions of each type of disability for public safety are listed here, which is important when you're helping a member review the information and decide which type of disability to make application for. 38844 requirements for disability pension is also a great area to keep in mind, especially paragraph B. Constantly looking at that paragraph, there's a lot of information in there to read through, but it does have good information. And local boards, the 38847, does have information that'll help boards go through that process with just little bits of information in there that note, excuse me, that the process for boards, including the 90 days after receipt of the application, the local board should be meeting, or within those 90 days, the local board should meet and at least accept the application. And 38859 medical boards, super important to review that, especially paragraphs B and C, I believe, that has good information in there regarding what the boards need to review and how to choose a medical board in order to review the individual member's disability. Model uniform rules are always good to keep on hand. There is a section in there about disabilities and rehearing that does have a lot of useful information. The local board retirement manual, that has towards the end of the manual pages about the disability. It includes the definitions, the calculations, examples of letters that you would send out to member doctors, requesting, examples of requesting medical records if need be. So there's good information in there too. And the one place you will find the application for a disability is in the retirement spreadsheet. Public safety disabilities, there are 4 that members can make application for. 3 of them are work-related. Ordinary is non-work related. So you have accidental, catastrophic, and temporary, which are work related, and then ordinary. When it comes to the different tiers, tier 1, tier 2, and tier 3 define benefit. The members are eligible for all 4 disabilities. For tier 3 DC, it's work-related disabilities only that the individuals could make application for. And tier 3, what has been provided to those individuals, because they do not contribute during those first 90 days. They are making in that decision period. But if something does happen during those first 90 days, the individuals are eligible for accidental or catastrophic, and then it's work-related disabilities. So an accidental disability under public safety, again, work-related. It's a physical or mental condition that the individual could make application for. Again, the key words in here, total and permanent. It does prevent them, the individual, from performing reasonable range of duties within the job classification. And that's why it's important to review the definition of each type of disability to ensure that you're looking at what it's for, basically. Is it total and permanent? Is it prevents them from do reasonable range of duties within the job classification or within the department? That's why it's super important to look at the definitions. And for accidental, it's either under 20 or over 20 years that the member could have on record when they make application. Accidental is also available if individuals are participating in drop. Now, accidental is going to be available because in order to participate in drop, the individual has to have 20 or more years of credited service. So an ordinary disability would not be available because their requirement under drop is, again, 20 years of credited service. So that's normal. They've reached normal retirement technically when they've entered drop. But again, the member can make application if they are participating in the drop program. And again, it's typically accidental that we see because the member is not contributing to the plan and neither is the employer. They've already reached that normal retirement eligibility. So accidental is typically the type of disability we would see coming across our desks. Ordinary disability for public safety, non-work related. Physical can doubt the definition of ordinary, it's going to split it out because of how it's set up. So ordinary non-work related, it could be a physical condition that prevents the individual from performing a reasonable range of duties within the department. Again, different verbiage and different definition for ordinary. And it breaks it out to say, or mental condition that totally and permanently prevents the individual from engaging in any substantial gainful employment. And under ordinary, it would be available to the individual as long as they haven't met normal retirement. Because typically, the way I think about it is an ordinary disability is taxable, just like a normal retirement is. So if the member already reached normal retirement, it doesn't make it effective to go and make application for the ordinary. And the ordinary is not available for Tier 3 defined contribution members or the Tier 3 individuals in their first 90 days. Temporary disability under public safety is work-related, and it's payable for 12 months only. So it's going to be a physical or mental condition that totally and temporarily, again, definition, when you read it, those are super important to know the difference, totally and temporarily prevents the individual from performing reasonable range of duties within the department. It is not available if eligible for normal retirement. And again, it's payable for 12 months only. So our office will indicate what those 12 months are going to be. And then the first of the month following those 12 months payment, we will stop that pension. So the member does have to keep that in mind, and the local board, because sometime within those 12 months or at the end of those 12 months, in order for the disability to continue for that member, that individual does need to make application for an accidental or an ordinary disability. And you'll have to start the process all over again with going through those steps to either approve or deny that accidental or ordinary disability in order for the individual who was receiving that temporary to continue receiving a disability benefit going forward. Catastrophic under public safety is work-related, but it's a physical condition only. And in this case, it totally and permanently prevents the individual from any gainful employment. Now, when we calculate this pension, it's important to know that the 90% for a catastrophic disability is payable for 60 months only. and then the pension will be reduced. Now, the other piece of information to keep in mind is the local board will reevaluate that disability if the member has not met a different criteria, which I will go over in a minute. But the local board needs to determine if the individual is unable to be gainfully employed still, even at the end of those 60 months. And it is based upon a medical exam. So the local board is going through those steps in order to appoint an IME, get medical records from the member, and have that independent medical exam again to determine if the individual is still eligible for the catastrophic or not. So under the catastrophic, again, it's work-related, physical condition only. The average monthly compensation for the first 60 months is 90% of the average monthly compensation, which I'll say again. It is non-taxable for that period of time. After 60 months, the pension amount is reduced, and it is noted on the calculation page when it is completed. It'll show what the percentage is at 90%, and then it'll show what the calculated amount will be when it's going to be reduced. And we automatically at our office, at the end of those 60 months, we will reduce that pension amount because statutes do direct. So we'll take care of that on that part. I think on the next slide, yes. But what needs to occur with a catastrophic disability is the local board must evaluate if the individual is still eligible for the catastrophic, even though we are reducing the pension amount, because the individual must be unable to engage in any gainful employment. If the local board determines the member has sufficiently recovered and is able to engage in gainful employment, then that catastrophic disability will stop. And the member will have to make application for an accidental disability at that point in order for, again, the benefit to continue on. That's only if the catastrophic is determined by an IME medical exam that they are able to engage in gainful employment. Now, the one piece that an employer did point out to me several years ago when we were reaching out to have them review the catastrophic disability is that a local board does not need to review if the individual who's receiving the catastrophic disability would have attained 25 years with the time that they had been receiving that catastrophic disability payment for those 60 months. So at the end of the 60 months, looking at the member's record, would they have attained 25 years? Yes or no? If yes, they did attain over 25 years of service, then the local board does not review. That catastrophic stays as is. Again, the pension amount will be reduced because that is directed in statute, but their classification of catastrophic would remain. I think at the time we were doing this, an employer pointed that out because when the individual was awarded the catastrophic, they had 23 years of credited service. And so by the time that 60 months had been payable to the individual, they had already attained more than 25 years of service looking at it. And so that's why the local board did not have to review. But again, we will reach out to the board and just kind of a reminder that they do need to review the catastrophic at or near the 60th month in order to ensure that the individual is still eligible for that catastrophic. Corrections officers. Again, I'm going to note the statutes because they have under the corrections officers, we have the different definitions. The disability qualifications are listed there. It's broken out between 38,886 is accidental and total and permanent. 38,886.01 is ordinary, because ordinary came around after or later in the years, I think like 2006, I believe, ordinary came around. So they split up that statute to list ordinary separately when that occurred. Again, information about local boards. The Corp has their model uniform rules, which is always, again, helpful to keep in mind. Local board retirement manual. What it does in that local board retirement manual on the last few pages of that resource, it does have what it combines Corp and public safety in the information it provides, but it is still good information to know that it's a good resource for boards if they need information to provide a member, sample letters and such. And again, the application, which is 2 pages for the disability, is in the retirement spreadsheet. Now, Corp has 3 different types of disabilities. It has the 2 work-related and 1 non-work related. Accidental is work-related, total and permanent is work-related, ordinary is non-work related. And under Corp, Tier 1, 2, and 3 DB, especially Tier 3, which is just AOC, all 3 disabilities are available, work-related and non-work-related. Tier 3 DC is work-related only. And again, for Tier 3, those Tier 3 members for the AOC who get that choice of DB, DC, during the first 90 days, the work-related disabilities are available to the members.
Just checking in, wanted to touch.
Ordinary disability under Corp is non-work related, physical condition that prevents the individual from performing a reasonable range of duties within the department. Whoops. And again, under Corp, they do again split out in a sense and talk about physical condition or mental condition. So it's mental condition totally and permanently prevents individuals from engaging in any substantially gainful employment. Not available if eligible for normal retirement. And again, the ordinary, though, is not available for Tier 3 DC members under that Corp plan. Accidental disability under Corp is work-related, physical or mental condition that totally and permanently prevents the individual from performing reasonable range of duties within the department. And again, it's either under 20 or over 20. It is the way we kind of refer to it because we code it separately because of taxation under public safety and Corp both. Corp disability, total and permanent. This is one that I don't really see very often anymore. In the past, we may have seen a bit more of this type of disability. The difference between accidental and total and permanent is, again, it's in the definition. While the total and permanent is a physical or mental condition that totally and permanently prevents the individual from any gainful employment under or over 20 years, part of that definition also goes on to state that it is the direct and proximate result of the member's performance of the member's duty as an employee of a participating employer. So it goes on a little bit differently for the definition of total and permanent than it does accidental. So as I mentioned, in order to get to the application for a disability under both public safety and Corp, those forms are available and the retirement spreadsheet. So on our website, under Forms and Resources and Employers, there is an area all about retirement spreadsheets. Since our website was just updated recently, it's a little bit different in how you'll be viewing each of those links for the retirement spreadsheet. It's going to start with Corp in the list and go to Public Safety alphabetically. So once you do open up the spreadsheet, it's a matter of looking at the input page. At the top of the page, it has today's date. And just to the right of that, you'll find these examples of a list of benefit type. So you'll need to click on the type of disability the member would like to make application for in order for the appropriate forms to show at the bottom of your screen on that Excel spreadsheet the way that they should. Now it's an old spreadsheet. It can get cranky. So if you click, and it automatically comes up with normal retirement like the screen shows. If you click on one of the disabilities buttons and it doesn't change those forms at the bottom, click back on the normal and then click back on one of the disabilities and it should change. If not, you can certainly reach out and we'll get you the documents that you need. This is just a simplified version of a flow chart regarding the disability process. And it's always good to know that the member does need to partner with the local board secretary in order to start this. And it's good to keep in mind that open communication needs to occur between the member and the secretary and the board to keep everybody informed and up to date as to what's going on. That's always seems to be the challenge with this, because we'll get the calls. And so then I'd have to reach out to the board and go, okay, what's going on? So if you keep that open line of communication, it's going to be helpful. The local board secretary is going to start that retirement spreadsheet. Now, once that, and all you need is the 2 pages, the P5EE page 1 and 2, or the C5EE page 1 and 2, in order to start the process. Once that application is completed, and a completed application includes the member information on that first page, along with the date of disabling event, nature and cause of the disability and information there, and a list of doctors the member has been coordinating with, or hospitals or clinics. And also to what I also mentioned to members, if they call our office, is in order to help that process move along in a smoother manner and maybe a little quicker, is if the member can compile their medical records in order to be able to present it with the application. If not, page 2 of that application does have the waiver for that the member would initial in order for the local board to reach out to the doctors to get those medical records. I believe it's just simpler and quicker if the member can get those medical records and themselves, hopefully, and compile that. Now, again, I'm sorry, I meant to mention the second page of that application. Make sure that the member signs and dates it, and also the local board secretary usually will sign and date it. Those dates are important for our office when we go to review it. And the local board does need to meet before 90 days ends, or within 90 days. They either need to accept the application if that's all they've got, or if they have the application and medical records, if the local board can determine that they can move on, then by all means they can, and just go to that next step, which is appointing an IME, or independent medical doctor. So again, the next step, local board appoints the medical board. Local board would set up an appointment, send a letter, information to that medical board. The medical board reviews and responds back to the local board. Local board meets to review and determine what the IME had provided in their report and on the questionnaire. and then the local board could either deny or award the disability. So I'm just showing you what the application looks like for both public safety, and I have Corp on here too. And again, that the only information that would come forward onto this form from the input page of the retirement spreadsheet is member information and demographics, and then any spouse or children. Everything else is basically something that's going to be handwritten and indicated by the member on the form. So the important thing is date of disabling event or condition diagnosis and nature and cause of disability. When that's blank, that leaves us going, what's this for? Because we don't know, yes, we'll be able to review supporting information, but this is going to be my first view. What is the member making application for? And again, I'm checking on page 2 for the dates that the disability was signed off by the member and by the board. And here's the Corp version, very similar. I know that it's been our application for years. And so they are going to be similar because there wasn't a whole lot of difference when we built these originally that we needed to have, other than the benefit disability type and statute reference on each of these. So the questionnaires. So I'm just providing a view of the questionnaires, just to note, especially at the top right-hand corner, what the form is titled. So you've got the form P5LBA and the form C5LBA. And each of these, the reason why we tag the A on the end is because this is for the accidental disability. These are questions that were built into this questionnaire based upon statute. The first half of the form at the top is all about the local board answering the questions. And the bottom portion is for that medical board, MD, IME, however you want to refer, they do need to answer those questions at the bottom half of that form. Now, if the local board has reached a decision that they don't need to appoint an IME because they're going to be denying that disability, the local board does need to fill out that top portion of this questionnaire for each one of the questionnaires, just so you know. So if it doesn't take it, if that disability does not move forward to that IME, that's fine. That's a board review and decision to do that. But that questionnaire also needs to be completed as far as the local board portion. And this is the total and permanent for Corp. Again, these questions are from statute based upon this type of disability a member would be making application for. And so that's why it's important when you're opening up the spreadsheet to ensure you click on the correct disability type, so that the appropriate form for the type of disability the member is making application for is available to you in order to be able to get that taken care of. Ordinary disability, again, I did side by side for both public safety and Corp. This is a P5LBO and a C5LBO. And again, those questions are going to be geared. And if you kind of look at the medical board portion of the questions, you'll see that it does reference the definition of the disability ordinary. It's sort of, you can pick it out of that question that the IME does need to answer. And the catastrophic for public safety. So the type of, the form is the form P5LBC. And again, it's the top right-hand corner. When you open up the retirement spreadsheet and click on a catastrophic, it'll show this form at the bottom of the Excel spreadsheet on separate tabs. So you can make sure you have the correct questionnaire for the type of disability the member's making application for. This is also another form that we do require, which is the local board determination form. It's the form P5LB or this Form C5LB. So on this form, we're asking for member information regarding their service, work status, and then the determination portion is you're letting us know how the board made their what their determination is that the board made. Is it denied? Has it been denied? And then that would be the first one. First question, does not qualify for disability. If they qualify, then we're needing you to indicate which type of disability the member qualified for and the retirement effective date. And we just need the month and the year. So if a member terminates employment in June, then as long as all the dates follow through correctly from when they made application, the member would be eligible starting July of 2024. So it's always the first of the month following the member's date of termination, unless there's retroactive dates that we need to look at. But it's important that the document is completed. It is still part of our required documents at this point when local boards do determine a disability for a member. So this is just information that I've kind of put together regarding what a local board should be reviewing. Each type of disability has okay, so let me start on the other side here. Sorry. On the right-hand side, timely application. In statute, I know for sure for public safety, it's 38,844B, and I know it's under Corp both 38,886 and 886.01, where it talks about timely application. So the member does need to make application after the disabling incident or within 1 year after the date of termination. So the board's asking this question: Did the individual make timely application? Did or will the individual terminate by reason of disability? What is the work status of the employee? Is the injury or condition pre-existing? If work related, did the injury or condition occur while working? Is there sufficient medical evidence? So this is just information and questions that the board should be asking. And if you look at the questionnaire, that's typically what the local board needs to answer anyway, because most of these questions are on the questionnaire for the local board portion that they need to answer. And again, each type of disability has a questionnaire, so you got to make sure that you pair the questionnaire with the appropriate disability the member made application for. The questions on the questionnaire will be geared towards that type of disability. They're based upon statute. And if the board finds that their answers to some of the questions are no, then the disability could be denied. They won't have to send the disability on to an IME potentially. It just all depends on which question they're answering no to, and if they can deny it. So that's why it's important for the board to review this information when they are doing that first look through of the application and medical records. Another part of the statute that comes into play when local board is reviewing, again, this is going to be, some of this is in the questionnaire. It's both, it's the same information in both public safety and corp. The individual does not qualify if the local board determines that the injury occurred while engaging in felonious criminal act or enterprise. Service in the armed forces entitles the member to a veteran's disability pension, or a physical or mental condition or injury existed or occurred before the date of membership in the system. So that specific part of the statute is there for both public safety and corp, and it's exactly the same. So that's why I just referenced that, because it's important for the board to review if they need to regarding that disability application. The medical boards. So there's different ways that we have referred to this, the medical board. It is referred to a medical board in statute. Or we talk about it as an independent doctor or MD or an independent physician or an independent medical exam. It's various ways depending upon who I'm talking to or depending upon how, if they're new or if the local board is new to processing the disabilities or if they've got a handle on them, which a lot of our employers do here in the Valley. We refer to it as an IME. Just so you know, and what our point of reference is when we talk about that independent doctor that the board needs to appoint, because the local board does need to appoint that MD in order to evaluate the member's eligibility for disability. Again, it's going to be a designated physician or physician working in a clinic, and it can be an MD or a DO. And it's good to keep that in mind because once we review those disabilities, if it is a mental condition that the individual is making application for, and the IME that's supporting the award or denial is a PhD, we're going to kick it back to the board and request that they obtain the IME from an MD or a DO because it is specifically listed in statute that it does need to be a physician. So that is an MD or a DO when I Googled it. But anyway, that's also what legal has opined on through the years. And it does need to be other than the employee's physician or the employer's physician. So that's why when the member makes application, they hopefully are providing you with all the information and all the doctors and such that they have seen. So that way you'll know which physicians not to reach out to because the member has already seen them. Finding of the disability it does need to be based on the medical evidence reviewed by the IME. And the IME, hopefully, as they have in these past few years, submit a report to the local board. It's when they kind of summarize everything on this in another fashion that you're going, what are they saying? So that's why hopefully you're getting a full report that kind of, notes that they met with the member, what some of the history is and all this and that they answer the questions on the questionnaire in detail on the report, and then also answer the questions on the questionnaire, the IME doctor does. If there's any conflict in the medical evidence, the local board does need to resolve that. And that's why it's important for the local board to discuss as much as they can in that open meeting and provide us with local board minutes so we know what the board did, what steps they took to resolve that so that we know this is why they awarded it. This is why the local board denied it. Because when we come into reviewing this and we do review all disabilities, we're coming in with just the paperwork that you're providing us. So it's helpful to provide us with information so that we know what the board did, why they did it, instead of just approved or denied, which I've seen those. And sometimes that works because you can tell what's happening from the IME report. But most times these days, it's much more helpful to provide us with as much information as you can regarding the disability in open meeting. And again, we are going to review those disabilities. So here's what we need in order to review the disability. We're going to need the form P5EE page 1 and 2. Now, when it comes to, or C5EE page 1 and 2. Now, initially, when that member makes application, part of the statutes under the local board rules do state that the board needs to advise us that the member's making application. So what we're asking for is that Form P5EE, page 1 and 2, or the C5EE, page 1 and 2. You can email that to localboards@publicsafety.com. Or, yeah, and we just need to know that that's started. 'Cause that's why we need just those 2 pages. Everything else will come later. So once the board has made their determination, we're going to get the application. We're going to get that Form P5LB or C5LB, because that notes the local board determination. The Form P5LBA or O or T or C for public safety, and the Form C5A or O or TP for PORP. We're going to need a copy of the IME report, and we're going to need local board minutes. And if denied, we will need a copy of the written notification to the member. Now, the member might have been in the meeting, so they were notified, but it's always good to follow up with written notification to the member. Even though in statute, I know for sure under public safety, it says either or, but again, it's always good to follow up with that written notification to the member. Rehearing. So if the disability is denied, again, notification to the member. And like I said, it's certified mail or member attended the meeting. Again, it's always good to follow up with something in writing to the member so that they have that. Within that notification, if you go to the sample letter that we have on the local board manual, it does have information regarding the rehearing. So that way the member is notified at the time in that denial letter that they do have that rehearing option. The rehearing request from the member does need to be filed in writing with the local board or the secretary within 60 days after the notification. So that's why it's always important to have that letter to be able to track those 60 days. Let's see here. If the member does follow up with a request for rehearing, remember that the 90 days starts over again. And that 90 days applies to everything that the board gets request or claim from the member on. But we focus on the disability part because it's so important to keep that moving, that disability moving in a timely fashion. So just remember that, if that request for rehearing comes in, you've got the 90 days with which to schedule that rehearing and advise the member what's going on. So another piece of reference to keep in mind is the model uniform rules. What it does in there, it does give some timelines, I would say. So it's when it comes to a rehearing request from a member, the member does need to provide more information, something in order for the board to be able to review it to determine if, yes, we're going to stick with the denial, or now that we have this additional information, maybe we can appoint an IME if we hadn't done before, or maybe we can have the IME do an addendum or something so that, but the member does need to hopefully provide more information. And that's, it's recommended to be with the local board secretary 10 days before the rehearing. Again, that's noted in the model uniform rules. So that's why it's always good to have those model uniform rules handy too, to reference. I have gone there often for both the public safety and corp in order to kind of help boards with some of their questions that they have on the disability process. Let's see. After the rehearing is held and the board decision is rendered, again, public safety, we will review that also if that rehearing does take place. So we do need, again, whatever information in additional that has occurred in order to be able to review that board's decision. So when it comes to a disability that's awarded to a member, a local board can do a review of those disabilities depending upon if it's public safety or corp. And under public safety, the local board can review the disability annually if they choose to. They would need to appoint an IME, get any sort of medical records more current from that individual to present to the IME and get that to that IME to be able to review. If the individual is determined sufficiently recovered and is offered employment by an employer but refuses, then the pension is stopped. It does not apply after the retired member reaches what would be normal retirement. There's a whole step process if that does occur where the IME determines that the member has sufficiently recovered. There's several steps that occur with that, and one of the major ones is the individual getting offered employment. But usually a lot of the disabilities do continue on for the individual. So, but if for some other reason it is determined that the individual is sufficiently recovered, then you can always reach out to our office and we'll tell you what next steps are. Because again, it doesn't happen very often. I don't think it's happened since I've been here, but there are statute reference for that. Under corp, the local board can periodically reevaluate the disability. It's a little different under corp. If the member refuses, the local board may suspend their pension. If the individual and the refusal by the individual continues on for a year, local board may stop the disability. But again, any sort of review does not apply after the retired member reaches what would be normal retirement. And again, that's under both public safety and corp. The review does stop if the member reaches what would be normal retirement. Okay. That is it. So Harold is going to be taking over here. So